India Legal makes the difference because we bring you only the news that counts.
India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. Actually, this is the first in a series of three readouts we are going to bring to you, which are related in nature, and I'll go into that a little later. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. In this latest readout, the first in a series of three, we focus on our new Chief Justice, the 50th since independence. He has now completed just over a month in office and his burdens are mounting. Uneasy lies the head that wears the crown. The ascension of any judge to the top of the judiciary is a momentous occasion, and it's lonely out there at the top. But moments are fleeting. They evanesce. Before you know it, they're gone. Either you've seized them or you haven't. At the end, all that's left is a lifetime to reflect on whether you stood up to be counted or whether you chose to ignore the call that that comes once in a lifetime to a chosen few to rise above and transcend the temptation to remain in the comfort zone of safety and mediocrity. So, at the age of 62 years and 11 months and 29 days, Justice Dhananjay Yashwant Chandrachud became the youngest Chief Justice of India over the last 10 years. What I'm holding up for you is a special edition of India Legal, that we brought out on the Chief Justice's ascension. You know, for the next 2 years, this debonair, scholarly, judicial luminary known for his erudition will navigate the nation's judicial minefield as master of the roster. These are not the worst of times, but they're not the best of times either. My hunch, as I wrote 2 years ago on Republic Day, is that India survives the worst and emerges stronger after our bloody partition of 1947. What emerged after that was a stronger India, aflame with poverty and exploitation, but led by wise men and women who kept anarchy and class warfare at bay with minimal repression. There were famines in the early years, caste discrimination, misogyny, patriarchal hegemony, mistreatment of widows, outbursts of religious savagery. But the idea of a constitutional India guided by principles of liberty and the rule of law held. But as always, these are trying times that test the souls of men and women. The larger portion of this special issue of India Legal is devoted to giving ourselves, our readers actually, some scholarly insights into the life and times of the new Chief Justice of India and his challenges. Among the writers are giants like the redoubtable Professor Upendra Bakshi and the iconic former Indian Chief Justice M.N. Venkatacharya, who is also the patron of the India Legal Group. I cannot match their unique perspectives, but what I can provide is a contextual approach from the viewpoint of a journalist who has watched closely the interplay between the three branches of government over several decades. Since I reported many of these developments at first hand, I'm going to rely heavily and quote verbatim in the essay that follows, quote verbatim from some of my own stories penned while I headed both the India Today and India Legal editorial teams. First, because I cannot put these thoughts any better now than I did then. And secondly, because there's a deja vu. Characters have changed, scenarios have not. And the basic flaws I sense in our government, the governmental architecture really, and arrangement appears to be hydra-headed. Once again, even as the ink was dry on the paper confirming Chandrachud's succession, the executive branch was reiterating its decades-old call for changing the Collegium system and replacing it with the NJAC. It's a new fight brewing between the judiciary and the executives. The present system, the Collegium system, gives the Supreme Court a measure of autonomy in judicial appointments, as well as raising the issue of judicial interference in the affairs of the executive. And this despite the flack that the higher judiciary is facing for leaning heavily in favor of the state apparatus in politically sensitive cases. The bugle, it seems, has already been blown. This brings me to the centrality of the issues that are the subject of this essay. Many things have changed since January 26, 1950, when our founding fathers gifted us this republic. But have we been able to keep this republic? While we have established our national government and fundamental laws, we need to examine whether the separation of powers between the executive, judiciary, and legislature operates as it should. This is a critical system of the checks and balances that ensures the sovereignty of the people and accountability of the government. You know, when our founding fathers adopted the parliamentary Westminster system from England, it may have been suitable at that time, but today, as the government has spread its tentacles into every aspect of our personal lives, the challenge is to keep executive excesses in check. It is not possible when the legislature, our parliament, is a slavish extension of the executive. The minister who's in the executive branch cannot be subjected to cannot be expected to police himself when he is simultaneously a legislator and also in charge of the civil services. Both under the doctrine of separation of powers are expected to be watchdogs over the executive in order to ensure that it carries out legislative mandates and does not exceed the authority given to it by Parliament. It is also incongruous when, under an archaic British law still in the statute books, a state government can order the dropping of criminal charges against legislators and supporters stemming from violations when its members were not in elected office. We need to seriously look at constitutional changes that will guarantee the independence of the legislatures as well as powerful guardians against fraud, waste, and corruption. How we can do that is another story. But for the time being, the judiciary seems to be playing that role. Or given recent developments, is it? Social tensions and internecine hatreds and violence and bigoted resistance to free expression and lifestyles are mounting. India's venerable Supreme Court has mostly risen above politics. It has tried to grapple with the executive excesses such as the misuse of Article 356 and assaults on the right to privacy. But in this surcharged atmosphere of the politicization of the steel frame of Indian governance, exemplified at one point by politicians calling for the impeachment of sitting Chief Justice. Will India as a nation rise above the baser instincts on the strength of the common sense and goodwill of its own people? As I observed in one of my essays in India Today, way back in 1996, all societies, whether they are monarchies or dictatorships, have a legal order, rules of civilized life, such as not stealing, honoring contracts, settlement of property disputes, marital disputes, that are backed by authority or sanction, but not necessarily a constitutional system that is based on an order of checks and balances between the executive, the legislature, and the judiciary. The concept of accountability of the executive dates back to the Magna Carta. In this scheme of ordination, a liberal constitutional system, Parliament formulates the policies and is also a judge of their wisdom and efficacy. The executive implements them and interprets the public interest, while the judiciary ensures their constitutionality and legality. It does not, as a rule, concern itself with the wisdom or popularity of that policy. That is ultimately left to the people of the land. I wrote this in the context of commenting on the now famous or infamous Jain Hawala scandal that rocked P.V. Narasimha Rao's government in the late 1990s. The Jain diaries contained the name or the names of a veritable who's who of India's ruling establishment, including Rao's ministers. You remember Rao was then Prime Minister, Congress Prime Minister of India. Now these names included Rao's ministers, who allegedly took bribes in return for political favors. Now when the CBI and related investigative agencies began dragging their feet on the issue because of political pressures, the Supreme Court swung into action to ensure that there was no cover-up. For the Supreme Court of the land to be virtually dictating terms to the CBI in the Hawala case, in other words, telling the executive how to do its job, is a reflection of a systemic breakdown of the other branches of the government, I then wrote in India Today. A political commentator, Cho Ramaswamy, the late Cho Ramaswamy, observed at that time, if there's a hero in this game, it is the judiciary. And the presumption of legitimacy of judicial intervention is also a presumption of the illegitimacy of the executive branch for failing to reach constitutional goals. In a society in which corruption is no longer an aberration, but rather the rule, all people need something to guide them in their personal lives. They may look to religion and religious books. In civil society, the Constitution has a life of its own, but it speaks only through institutions, and one institution breaks down and other becomes more powerful. If Parliament fails, the bureaucracy becomes more powerful. If the executive is weak, Parliament assumes a stronger role. If both lose their credibility by abdicating their responsibilities, then the courts begin concerning themselves not only with policies, but also examining their wisdom and need. The 90s were replete with the interference of the Supreme Court in areas where judicial angels had feared to tread in the past, raising the retirement age for judges by what amounted to a virtual judicial fiat, fixing quotas and even fees for medical colleges. In the normal course of events, it would have been unthinkable for the Supreme Court to be summoning the head of the CBI to report on the Hawala inquiry, even before the designated trial court had taken cognizance of the final report. I noted in that article in 1996 that what the Supreme Court of India is doing for the first time is not without international precedent. In 1993, Italian judges became public heroes following the arrest of more than 1,000 people, including cabinet ministers, in a kickback scandal involving organized crime. Similarly, heads rolled in France, in Germany, and in Spain. And last year, former South Korean President Roh Tae-woo was jailed on charges of bribe taking in many of these countries. People's movements, backed by the judiciary when it took the executive to task, in India, public opinion is slow to crystallize on corruption charges, but once enthusiasm builds up, there's no stopping it. Bofors, the gun scandal during the Rajiv Gandhi time, Bofors caught fire because it involved Dalali on a matter of national defense. But here too, while a prime minister and a political party were punished at a political level, the investigative agencies and the judiciary appeared indifferent to the probe. In that sense, judicial activism on the Hawala scandal is a belated awakening, or was a belated awakening, to the fact that VIPs escape probes and charge sheets no matter how serious the offense. Call it collective penitence, if you will. The concept of insaf, justice, I wrote, is deeply embedded in the Indian psyche. And whenever there's a convergence of public opinion and judicial statesmanship, the judiciary takes upon itself the task of examining executive policies and the general direction of the nation. The argument about judicial dictatorship or the danger of judicial tyranny is a valid and legitimate concern. After all, what checks are there on a judiciary that runs amok or decides to use the CBI or other investigative agencies as a private Gestapo? For there is only a thin line dividing the exercising of legitimate authority and untrammeled power. Technically, the checks are inherent in the judicial process, under which the process of reasoning, proper hearings, and rationality are obligatory. That decisions must be well reasoned, that judgments must support themselves on neutral principles, that they must be uncontrived, and the efficacy of a judicial order should depend on moral sanctions and restraint, and not just on coercion. Justice Chandrachud has been universally applauded for his refined intellect, his modernity of outlook, expanding the rights of women and speaking out on individual liberty, which he continues to do, the right to privacy, and decriminalization of homosexuality. The bouquets he receives outweigh the brickbats, but the brickbats also fly his way, often from his friends and admirers, who sometimes fail to understand his stand on politically sensitive cases such as the death of Judge Loya, the contradictions in the final Ayodhya judgment allotting the disputed land to the parties found guilty of illegal demolition, or the Hadia case in which a national security probe by the NIA was ordered in a cross-religion love marriage. Now, it is not for me to advocate in this space how a nation's Chief Justice should conduct or rule on any specific case, especially the sensitive and challenging constitutional issues that are pending, issues that test the very fabric that India is bound by, that binds this land into a nation. The issues I have raised here are recurring institutional concerns, and the people responsible for dealing with them and resolving even a few of them will themselves become institutions. For the antidote to a constitutional system that threatens to swing out of balance is not just the appearance of honesty and integrity, but an honest and aggressive display of it. As Justice J.S. Verma at one time so eloquently observed, keep the top clean and whatever trickles down will also be clean. This is your host, Inderjit Badhwar. I'll see you again in another video. Until next time, goodbye for now.
India Legal, stories that count.